All rise. The Court of Appeals Division 1 is now in session.
Please be seated. This is the time set for argument in our cause number 1, CV22 0506, Silk versus Blodgett. Counsel, we have reviewed the record and the briefs in this matter. We've discussed this case at conference this morning. Both sides are given 20 minutes to present your arguments to the court. I would remind the appellants that if you want to reserve any time, it is incumbent upon you to do that. When you step to the podium, if you would please announce the party for whom you represent, and with that, we will begin. Counsel.
Good morning, Your Honors. May it please the Court. My name is Trevor Courts with Aspie Walken Diesel. Here with me in the courtroom today is Whitney Cunningham. He's also on the briefs. We're here today on behalf of appellants Terry and Melinda Silk. What we have here is the Lake Havasu City Board of Adjustments erroneously interpreting the development code to allow for the construction of a roughly 20,000 square foot under roof, approximately 50-foot tall building in a residential estate neighborhood. This building is 5 times larger than any home around it. Now, when you have such an absurd result, something that's so out of scope and out of character, it begs common sense and it begs a proper interpretation to prevent such results. Now, frankly, a proper interpretation of development code would also prevent the Blodgetts from being able to, and this is in the words of Superior Court Judge Jansen, from being able to beat the system somehow.
Counsel, is this house already built?
It is probably at least close to construction. Whether it's completely finalized, I'm not entirely sure on that.
Okay, thank you.
Now, when you have a result from the Board of Adjustments that...
So I guess just following up on Judge Brown's question, if we rule in your client's favor, what is the practical result of that?
Yeah, I think that's a good question, Your Honor. I think there's a couple different things that could happen here. What we know for sure, and this issue has not been briefed yet at the Superior Court level, but what we know for sure is that pursuant to the development code, if this permit was issued in violation of the development code, it has to be deemed void. What that means is you have an unpermitted building, and the city would have to deal with that. So the city would have to look at its codes and see, okay, what are we going to do with this unpermitted structure that's already been constructed?
Well, it wouldn't prevent them from going back and attempting to get a new building permit, correct?
Correct, Your Honor. And depending on what this court found the error came from, there would have to be some sort of adjustment, either to the size or scope or the design of the structure to come into compliance.
Well, what if we disagree with you on the substantive part, but agree with you on the procedural part?
As far as the zoning clearance, Your Honor?
Yeah.
At that point, I think what would have to happen is they would still have to submit for zoning clearance and have to go through the formal zoning clearance process, at which point if the zoning administrator would then have to look at these same issues we're talking about, building height, setbacks, all these things that are required for the zoning clearance and determine whether it meets those requirements.
Have the code provisions on height or multifamily dwelling changed at all since the original determination?
No, Your Honor, not that I'm aware of.
So would you have the same zoning administrator, assuming he's still there, looking at the same issues and presumably issuing the same decision?
To be clear, Your Honor, the zoning administrator testified that if he had filed a physical zoning clearance, we would have had the same result, but we don't really know that to be true because it didn't happen. And so we'd at least need to go through the zoning clearance process and make sure that those requirements are met.
Okay, but I guess we're struggling just procedurally. If we say we agree with you, it wasn't done properly, send it back for clearance. So signs off on it, and then could they raise additional arguments before the city would issue a permit?
I think we'd still have the same questions on whether the building height and the duplex issue is addressed.
Well, that goes back to my original question, is what if we rule against you on the substantive part?
Yeah, so if you rule against the substantive part, then I think that the issue then is just getting the zoning clearance. I think it's just a procedural step that they'd have to take. I don't think it would practically change what the design of the structure looks like. Now,
I mean, I suppose you could make new arguments based on new information about whether the wet bar is a kitchen or not.
Correct, Your Honor, and I think the issue there is the board heard that argument. The board already kind of ruled that this was not a duplex, and that's why we're here also, is we think that ruling was erroneous as well. So if you found against us on that as well, then I think you're looking at the procedural issue. Yeah. Now, there's not a great deal of dispute here regarding the facts, but what we do have is a dispute of the statutory interpretation. So I think a logical place to start is what is the standard of review here. So for issues of statutory interpretation, this court is free to look at this de novo. You're not bound by the standard of arbitrary, capricious, or abuse of discretion. Now, what the Superior Court did, the Superior Court said, well, we're going to give substantial deference to the board, and we're not going to reverse unless arbitrary, capricious, or abuse of discretion. That's not the standard. The Superior Court simply got that wrong. Now, case law is clear that this court is free to draw its own conclusion on whether the board erred in misinterpreting the law. And this court is free to use its own judgment in place of the board's on how that interpretation affects the underlying facts. Now,
And I think I agree with you on the zoning clearance issue and the height issue. Those seem like legal issues that just require us to interpret the provisions in the code. But the issue of whether it's a multifamily dwelling or not seems like there is some facts there. What is in the design? What was the design intended for? So that to me seems like a mixed question of law and fact that we would owe some deference to the board on. What is your comment on that?
Yeah, so I think the issue regarding the duplex issue is what does the word or the term designed for mean? So that's an issue of statutory interpretation. What does it mean when the code is saying designed for? And you do have to look at some underlying fact there, but this court is free to use its assessment in the place of the boards on how the interpretation of it is designed for affects those underlying facts regarding, is this a wet bar or kitchen? Does the total structure design look like it's two-family or single-family? Now, it's important to remember when you're looking at this that courts have long recognized that a board's decision is not infallible. This court has to remain final authority on these issues. What we have is a volunteer lay board that hadn't convened for 6 or 7 years prior to this hearing. They were hastily put together, and while they did their best to interpret the zoning code, we think they simply got it wrong. What they did was they relied on a report and a presentation prepared by the zoning administrator, whose very actions at the beginning gave rise to this appeal in the first place. So that's why this court needs to step in. They need to take a fresh look at whether these interpretations were correct or not. Now, from the beginning of this process, we think that the city erred. So prior to a building permit even being issued, they had to have a zoning clearance. Now, this code sets forth two very clear requirements for what's necessary for a zoning clearance. First, it has to be filed in conjunction with the building permit. And second, the zoning administrator is charged with issuing that zoning clearance only after finding that the project complies with the applicable provisions of the development code. We contend that simply didn't happen. The zoning administrator testified that nothing was filed. When we're interpreting the statute, we have to look at the plain language and we have to give meaning to all of the words. It has to be filed, it has to be issued. Now, I think it makes it even more clear when it says that no person can alter a structure without first applying for and obtaining a zoning clearance. This implies that there's a separate process here. Now, the city's actions in other projects for commercial, multi-use, TI, I think those also make clear what the city's interpretation has been longstanding. They require a formal application, and after doing the zoning clearance, they issue a formal notice of action. There's a filing and there's issuance. But apparently unilaterally, the zoning administrator has determined that for residential projects, that's not necessary.
And what is the practical impact of not having a separate zoning clearance? Is the public deprived of some opportunity to comment on that clearance?
I don't think there's an opportunity to comment, but I think that we have a result where we have now where we can't look back and say, was a zoning clearance actually performed? There's no record to show that it's actually performed. So if you have a question regarding a building permit, apparently you're just supposed to assume that it went through all the hoops that it needed to and that it was approved from the zoning clearance perspective.
Could the city include the building permit and the zoning clearance in one document?
I think they could, Your Honor, if there was a separate, or if there was a filing with zoning clearance, it could be on the same document, same fee, I think, too. I don't think you'd have a separate fee or anything like that. But I think you would still have a record showing that the zoning clearance is done. And
It just has to say, we conducted the zoning clearance review and we hereby approve zoning clearance.
I think that would show that a zoning clearance was done and would satisfy the requirements of filing and issuance.
Is there any significant, or not just significant, is there any event that is triggered by the zoning clearance? What, like, does it trigger any type of protest period or ability to challenge it?
It doesn't trigger a protest period, it just allows, you have to go through this process in order to have your building permit issued. So the public wouldn't necessarily be able to comment during this period, but it would ensure that this was done before the building permit was issued. The zoning administrator, and the city makes this clear, does not issue building permits. And so you have two separate departments, one doing clearance, one doing permit issuance. And you need to make sure that the clearance comes first before this department issues the building permit. The way to do that is to make sure that you have a record that the zoning administrator did his job in doing the zoning clearance first.
But if you challenge that the zoning clearance was done, the zoning administrator is going to show up and say, I did the zoning clearance. I just, qualitatively, I'm not sure how that's different than having that statement on a piece of paper.
Well, I think that there's no record for us to look back to before even issuing a challenge. So in order to apparently get the zoning administrator to say, I do the zoning clearance, you have to go to the Board of Adjustment and have a hearing. Whereas for commercial and other projects, you can simply look at the record for that building permit and you'll see a notice of action that says, all right, zoning administrator did his job. This complies with the sections that he had to look at. We don't have that here. And I think when you don't have the zoning clearance, you get absurd results like we have here. You get a roughly 50-foot tall structure in a residential estate neighborhood. Now, as to the issue of building height, I think this is simply where the board got it wrong as well. We have to look at a couple different provisions of the zoning code to really make out how this building should be measured from a height perspective. So everyone agrees maximum height here is 30 feet in a residential estate zone.
Do you agree this is a downward sloping lot once they were combined?
Yeah, I think that makes sense, Your Honor. So what we have is the existing house on Eagle Lane, downward sloping on a Palmer Drive. I think it makes sense that the zoning administrator determined that this was a downward sloping lot after it was combined. Now, how we measure height is you look at the vertical distance from approved grade to an imaginary plane located 30 feet above average lot grade. Now, so we have an imaginary plane where you can build up to, and it's 30 feet above average lot grade. The zoning administrator tells us what average lot grade is. He says, okay, we look at the setback corners, and it's 86.25. This is all kind of in reference to a base elevation of 100. So we have lot elevation of 86.25. That's your average lot grade. Now, what the zoning code says is you're going to go 30 feet up from average lot grade. So you can build to a height elevation of 116.25.
That's for upward sloping lots?
For downward sloping lots.
No, but the codes, that under the code, my read of it is that is for upward sloping lots. Where you have a downward sloping lot, it's a different calculation that uses the 101 that is based on the middle of the road that's front facing the home.
Yeah, so I think...
And you add the 30 to the 101 to get 131, and we're there.
I think what you're talking about, Your Honor, is so what the code doesn't have different height measurement calculations. Height is measured the same, 30 feet from average lot grade. What the difference is between upward and downward sloping lot is, for a downward sloping lot, if your average lot grade is below base elevation. Base elevation is defined term in the code.
Base elevation here is the 100 plus the 1 is, or the 101.
Exactly.
The 86 is less than that, so you use the 101 to add the 32 is my reading. Tell me why I'm wrong.
I think what happens, Your Honor, is if the average lot grade is below base elevation, what the code said is you can import fill to create a building pad. It doesn't say, and this is what they're permitted to do, but they're not required. They're not required to import fill, but they can import fill to create a building pad at the base elevation of 101. They didn't do that.
I think they can fill up to the 86, right?
What was that, Your Honor?
I think they can fill up to the 86, which is the average.
They can fill up to 1 foot above base elevation.
Right, yeah, that's the 101.
Yeah,
Right.
so 101.
Right.
But they didn't do that. They kept the same grade that existed.
But the code doesn't say they have to do that.
Correct, Your Honor. But if they don't do that, they're stuck with measuring up from the existing average lot grade. The code doesn't say that you get to change and ignore the fact that you're supposed to go 30 feet up from average lot grade just because you didn't bring in fill. You're still measuring from average lot grade, and this code is grounded in reality. What is the grade on the lot? And we know that it's grounded in reality because grade is defined as the ground surface adjacent to the structure. We're talking about actual dirt here. The average lot grade of this lot is 86.25. You can go 30 feet above that and build to 116.25. What the zoning administrator said and what the board determined was, we're going to ignore that you're supposed to draw an imaginary plane above average lot grade. Instead, we're going to draw an imaginary plane above this theoretical maximum lot grade, which if we take this to its extremes, Your Honor, what that would allow is if you had a base elevation of 100 with a downward sloping lot of 100 feet, according to the city's interpretation, you could build a 130-foot tall structure from the back if you were looking at the back of that lot. It would go up 130 feet from the back structure. And frankly, I don't think that's what the code allows. It allows you to go from average lot grade. Now, for the issue of the duplex, the code defines what it means to be a dwelling unit. A dwelling unit is one or more rooms in a dwelling designed as a unit for occupancy by one family for living and sleeping purposes, having not more than one kitchen. Now, having not more than one kitchen is important here. So what we have...
And what do we look to determine what is a kitchen?
Yeah, so the building code, not the development code, the building code defines a kitchen as a place where you prepare food. Now, what we have is an existing structure on Eagle Lane. I don't think there's any dispute. This is a dwelling unit designed for use by a family. It has a kitchen. It was a house. Now we have this addition. It has bedrooms, has bathrooms. It has what's labeled as a wet bar, but it has a refrigerator. It has a double sink. It's got plumbing and a place for a stove. It's surrounded by a dining room, and it's surrounded by a pantry. This is a kitchen. Just because you label a wet bar doesn't change what the actual room is. So we have another structure that's designed for use by a family with a kitchen in it. Now, what a two-family dwelling unit is two dwelling units with separate entrances designed for use by two families.
Well, so this, it's also open to the existing structure, right? And doesn't your argument depend on that being closed off?
Well, I don't think the code doesn't separate what it means to be designed for use by two families, but the only way that this is connected is you have essentially a hallway, an elevated hallway above the existing pool that has a door at the end that goes into this new addition. So our contention, Your Honor, is that this door is no different than a party wall. You close that door and you have two separate houses. It has a garage from each frontage street, has its entrances from each frontage street. This is two houses connected by a breezeway. This is no different than a party wall. It's no different than rooms conjoining a hotel room. These are still two separate units. Now, what the board did was they said, well, do you want us to regulate the number of kitchens or we shouldn't be regulating the number of kitchens in a house. We shouldn't be regulating the number of sleeping areas. That's exactly what the development code tells them to regulate. You have to look at what the design of the house is, and this has to be an objective review, not a subjective review. What we have is the Blodgetts coming in and saying, well, we intend to use it for husband and wife. Well, that's a subjective view. If that's the case, then they could theoretically build a duplex with a party wall, come in and say, well, we're going to use it for husband and wife, and now apparently that turns a duplex into a single-family home. We have to take an objective view of what the actual design and layout is. I'd like to reserve some time for rebuttal unless Your Honors have any questions for me.
All right, thank you, counsel. We'll now hear from the police.
Good morning. Sorry. Good morning, Your Honors. Kristen Mackin. I'm here representing the city defendants of the city, Lake Havasu City, the Board of Adjustment, and Stuart Schmalling, the zoning administrator who was his own zoning administrator then and still is the zoning administrator of the city. So I think I'm just going to jump right into addressing, we'll go right to the standard of review, if we could. I agree that obviously this court, any court, has a de novo standard when it comes to a legal interpretation issue, but the issues with the development code and the interpretation that appellants raise are ambiguous language, which leads to the Board of Adjustment properly looking at all of the circumstances surrounding the interpretation. So not just the language, but the figure, for instance, for the height calculation, the language of the development code and the figure, and the city's ZA's testimony concerning his longstanding application of that. And so I do think it presents a mixed question of law and fact to that extent, because the Board of Adjustment is that special, that board convene with specialized knowledge to make those types of technical assessments and judgments, and they were the ones who heard the testimony presented and could evaluate the reasonableness and the weight of and credibility of the ZA's testimony and his longstanding interpretation.
Well, it could be a longstanding interpretation, but be absolutely incorrect.
Absolutely, it could. And in this case, the ZA testified at length as to how he made the determination based on the language of the code, including the illustrations. The Board of Adjustment members had a conversation about how a couple of the members had personal experience, and they agreed, they stated that this is consistent with how this code has been applied to me, the contractor.
Again, it could be how it was done, but it could be absolutely incorrect.
Well,
And if the law demands that certain procedures be in place, I'm assuming there's a reason. And if it wasn't done in this case, doesn't the code also say the permit is void?
yes, it does, but I think that if you want to talk about zoning clearance first, I think that the ZA very clearly testified that he did do it just because it wasn't written down on a piece of paper. When a building permit application is filed, comes across the counter, it gets routed to different departments who have, the application is relevant to building department zoning administrator. The zoning administrator said he looks at there's a couple of pages of the plans that he can review. He conducts his review. He walked the Board of Adjustment through exactly what he did when he received that application and those plans, how he conducted his zoning clearance. He okayed it, passed it along, and he testified if he had to do it again, he'd make the same determinations because that's how he interprets the code, which is at his discretion as a zoning administrator under the code. If there's any ambiguities, he's the one who makes the determination about how a code or the process applies.
The contents of the zoning clearance document, I might agree with you. We might defer to the administrator on what exactly needs to be in it, but whether there needs to be a document in the first place seems pretty clearly like a legal issue that is clearly addressed by the code. So why am I wrong there?
I'm sorry, I don't think I understand. You think there needs to be a separate document?
Yes,
in
that's the way
residential?
to me, that's the way the code reads. And so why would we defer to a zoning administrator and say, well, that actually doesn't need to be in there because you haven't done that for a long time?
Well, respectfully, I think when you look at the definition of zoning clearance in the development code itself, all it says is that it's an authorization issued by the zoning administrator. And authorization is not defined, but the Merriam-Webster.
But it says it needs to be filed, and I don't know how you file the zoning administrator's mental thoughts about whether this was proper under the zoning code or not.
Respectfully, I think that language is ambiguous because it says the zoning clearance needs to be filed in conjunction with the building permit application, and so it's not the zoning administrator who would, in that sense, would be filing a zoning clearance with the building permit application. At that time, there wouldn't be a zoning clearance yet. There was no process then for someone to apply for a zoning clearance in the residential context prior to taking out a building permit.
So there was no form, somebody couldn't come in and ask for the form for a zoning clearance form for a residential property?
Well, they probably
What you're saying
could.
is it didn't happen here, though? That nobody requested a zoning clearance?
Correct, nobody requested a zoning clearance, and I don't know what the city would have done in that instance if someone came in before they took out a building permit, filed their building permit application, asked for a zoning clearance because the zoning administrator determined that the process is implicit in the building permit application, which I do think is his right under the development code to be able to determine the processes.
But you would agree with me, the code says the clearance needs to be filed.
It does say the clearance needs to be filed.
So when was the clearance filed in this case?
I think it was filed, the record of it being filed is when the building permit is issued.
If we disagree with you,
Yes.
and we say the procedure was not done, and it was wrong, and under the code, it means it's void, don't we still have to address the substantive part because it's going to come up again?
Well,
The two
yes.
substantive claims. When I say substantive claim, the height and the kitchen issue. Don't we have to address that?
I think so. The zoning administrator testified that if he had to do the written document of a zoning clearance, he would end up doing the same thing. So it doesn't seem worthwhile to me. And as a side note, the certificate of occupancy was issued on the structure in February. So I do think that the height needs to be addressed, and I'm not sure, I know that it said that if a building permit is issued in violation of the code, that the building permit would be void, but I don't know if the zoning clearance is not issued. I don't know if that procedural step means that the entire the entire building permit is void if the substantive steps are complied with, the substantive requirements of the height and the, impermissible duplex setbacks, et cetera. So we can go to the height then, if you want to talk about the height. The concern, obviously, what appellants are saying that now that, once the lots were combined, that the average lot grade was below the base elevation. But I think that disregards the fact that there's an existing structure and an approved grade, and the zoning administrator explained that when the average lot grade is below base elevation, then you start with the 101 and you go up 30 feet, and that's consistent with the figure, the illustration in the development code. And so to the extent that there's an ambiguity there.
Other than the figure, though, is there any provision in the code itself that supports that argument?
Well, the definition of grade is from the existing structure, and here the existing structure is the one on Eagle Lane, already constructed with a 30-foot height. And when you look at the implications of appellant's argument, so now, granted, the Board of Adjustment had a long discussion about how this is a very unusual situation, and the development code really doesn't address what happens when you have two residential lots that are combined, especially with a very great height differential. So the zoning administrator did what he could to apply the code to this kind of unusual situation created by the subdivision code exception that the city had granted 15 years prior in 2005. So he testified that you go straight across, and so appellant's argument would end up that you would have either maybe two different heights, or you would immediately put the existing structure into a non-conforming use, and that just violates public policy, which is to eliminate public non-conforming uses and not to create new non-conforming uses. So I think that argument is problematic there, or would require, also would be contrary to how the city has interpreted. The ZA applies that to every residential property, which also was part of the Board of Adjustment discussion.
Let's say we disagree with you. What would the practical impact of that decision be in terms of this building?
Well, then, since they see if it was truly void, then it would go back to the city. The city would then, the owners would have an opportunity. They would probably argue that there's an estoppel argument, or that they may apply for a variance from the height exception and go through that process. So I don't know how the city would address that at this point.
On the kitchen issue, did the Silks waive that argument?
Well, we didn't address it except for...
It seems like there's maybe a bit of a disagreement between the city and the Blodgetts on that, so...
Yes, so they didn't raise it, so the zoning administrator wasn't prepared during the hearing to testify, and he said he knew it was a part of a building code, but obviously he's not the building official, so the city didn't have a building official there to discuss it. In his opinion, he thought that it was designed for one owner and one family, and the Board of Adjustment had a conversation about that, and respectfully, appellant's argument that, well, it could be very easily split into two, could be made for probably any number of structures, particularly those made for and designed for families with large families that may have more than one dining room or pantry. So I think this presents a factual issue as to how that is interpreted, and the Board of Adjustment made a decision that designed for must be that this particular home or addition was not designed for to, and therefore could proceed. That was the ZA's process that he considered.
And just so I'm clear, were the designs set up so that there could be stove, refrigerator, I know it said wet bar, but stove, other items that you would need to prepare food?
I did not review the building plans in detail, but it does appear, it does appear from the plans, that I read. I'm not,
That's why I asked you, because
Yeah, it looked like they had little, placeholders for those things. What was in the plans and what may have been in the final home or construction, I have no idea. If it could be changed, just like a wall could be added, or they could take out the refrigerator and put, the appropriate 5 cubic square foot refrigerator, or say, okay, well, we'll have a fridge here. And now all of a sudden you don't have a kitchen, so you don't have a 2-family.
What's missing from the wet bar that makes it not a kitchen? In your mind?
That's not in the zoning code. I looked up the building code yesterday, but it has to do with the size of the drains and the electrical outlets and the size of the refrigerators. So in my mind, all of those things could be changed, just like a wall could be added to create 2 separate properties. But the fact was, this was submitted by one family, requested to be a single-family addition. That was a representation. That was the representation of the owners. That was a testimony at the hearing, and respectfully, the appellants didn't present any evidence or testimony to the contrary.
A single family could submit an apartment building and say, we're all planning on living there. It's designed for just my family, and we're stuck with that?
I don't know that it goes that far, Your Honor, because this was already an existing one. It's like single-family home with a proposed addition. So I don't think, that has separate entrances, and it's more clearly intended to, plus the density that would be to build that document. But respectfully, the ZA wasn't given an opportunity to respond to those types of arguments because he didn't know. That wasn't raised until the argument at the Board of Adjustment.
Does the code address what happens if after certificate of occupancy is issued? What if maybe on paper this is what it says, but what if in practice, voila, it shows up on Airbnb for the lower unit? I won't call it a unit. The lower part is advertised as Airbnb.
Yeah. Well,
do the neighbors have an ability to be able to address that in any way through the code?
Yes, I think they would probably file a complaint, and then you'd have a zoning code violation for impermissible occupancy for a single-family home. And if you don't have any other questions, I do want to give my co-counsel time to.
All right, thank you.
Good morning, and may it please the court. My name is Eric Stanley, and I represent the appellees, real parties in interest, Eric and Gail Blodgett. This court should affirm the Superior Court for 2 reasons. First, the Superior Court applied the correct standard of review, and its decision was correct. But secondly, the argument I'd like to focus on during the few minutes I have, unless the court has questions on the other argument, is that the Silks argument regarding the multifamily dwelling unit was not properly appealed. It's undisputed that the notice of appeal that was filed by the Silks to the Board of Adjustment, which is in their appendix at page 57 to 63, did not contain or specify any grounds for appeal regarding the multifamily dwelling issue. That was not in the notice of appeal. The burden is on the Silks to show that they properly appealed that issue in compliance with ARS 9-462.06D. That requirement that the notice of appeal specify the grounds for the appeal cannot be waived.
Did your clients raise this argument with Judge Jansen in the Superior Court?
The argument was raised below. I think
where in the record is that?
If we look back, the plaintiffs alleged in paragraph 62 of their complaint that they raised in the Board of Adjustment the same issues they were raising in the Superior Court. Both the city and the Blodgetts denied that in paragraph 62 of our answers to the special action complaint. Also,
But did you ever separately argue that the argument had been waived?
well, yes, so in the city's answering brief in the special action before the Superior Court on page 14, the city did say, which the Blodgetts filed a joinder of interest in. The city said, as a threshold matter, plaintiffs did not identify this, the multifamily dwelling unit, as a ground for their appeal in their March 16th, 2021 appeal to the board. It was raised for the first time at oral argument on May 12th, 2021. The city was not therefore presented with an opportunity to respond to the allegation in its staff report. So that issue about whether it was properly raised was properly presented in the notice of appeal was raised to the Superior Court. But it's a jurisdictional issue. 9-462.06D specifically says you must specify the grounds for the appeal in the notice of appeal. The Supreme Court was very clear in the Neal versus City of Kingman case that there's two reasons for this requirement. The first being that the notice of appeal is to apprise the board of the issues it will be expected to decide, and secondly, to notify members of the public and interested parties of the nature of the appeal. We can see neither one of these purposes were met by how this all unfolded at the BOA below, because the BOA agenda does not contain the issue as part of the agenda that the BOA was going to hear.
The Arizona Supreme Court issued a decision last week in a case called Shea versus Maricopa that I think talks about some of these issues, and it seemed fairly forgiving in terms of what needed to be in the notice of appeal. Does that decision have any impact on your argument?
Your Honor, I am not familiar with that decision, so I can't comment on that. And I would be very hesitant to comment on that without reading it. But in this regard, I do think what happened at the Board of Adjustment specifies or really suggests why this is important, though, because the board was not prepared to deal with this issue. They did not have the building official there. The zoning administrator didn't even address the issue in his initial presentation to the board. He answered some questions from the board about it, but you could see the BOA was struggling a bit with this issue in the record. But importantly, no notice was given to members of the public that this was going to be raised so that they could discern whether they wanted to participate in this. So in that, it certainly was not raised. However, even if this court were inclined to reach that issue, to go there and decide, this is one of the issues that is very clearly under the standard of interpretation of whether the BOA's decision was arbitrary, capricious, or an abuse of discretion, which cannot be the case on the record here, where the only evidence was this was a wet bar. And the blow-up that was done on page 174 of the appendix to the briefs kind of shows that in some detail what was there, but also the Blodgett's testimony themselves, that they were the only residents of the home. What could hypothetically happen down the road doesn't deal with what the facts on the ground
Well,
are.
it's as designed, so it doesn't matter who owns it or what they say, does it? It's as designed.
It is as designed.
That has nothing to do with who owns it. I mean, you look at the plans, and what do the plans show in your mind? What do the plans show? Do they show a kid?
The plans in my mind show a wet bar, which is what it was specified as. You could certainly, put a stove in there if you wanted to, or whatever those things are. But I think this court...
So if it walks like a duck and quacks like a duck, it's not a duck, because you're calling it a chicken.
No, my argument is that the BOA's decision on this was not arbitrary, capricious, or an abuse of discretion. It looked at the evidence it had before it, and it determined this was not a multifamily dwelling unit. So even if the court is inclined to go there, it should uphold for those reasons on that. So we urge the court to affirm the Superior Court's decision.
All right, thank you.
Thank you.
Any final word?
All right, I think I just have two issues I want to touch on briefly. The first is the issue of waiver. So the Neal case cited by appellees talks about a case where the issue was not raised in the notice, and it was also not raised at the administrative hearing. And what the Neal court said was failure to raise an issue at the hearing that the tribunal is competent to hear waives the issue. This was raised at the hearing. The city appellees also tell us that it was raised at the hearing and that the city heard enough testimony to make a decision on this issue. We think they got that decision wrong, but they did hear enough testimony to make a decision on that. Now, as to height, the city asked us to look at this look at it differently because it has an existing structure there. The code doesn't care whether there's existing structure there. We have one lot now. The Blodgetts turned this into one lot, and they have to live with the consequences of having one lot. What that means is you now have a downward sloping lot with average grade that is now 86, and you can only build 30 feet above that. I don't think the code anywhere says that, well, we have to change this calculation because you built a house and then combined a lot later. The calculation stays the same. And with that, I'd leave it open for any questions from your honors.
Yeah, thank you. The matter is deemed submitted. We'll issue a decision in due course, and with that, the court stands in recess.